One, sir.
Huh?
This was very old case, sir.
It is of 2001.
Correct, predecessor. You have to blame old people.
No, sir. No, sir.
Then
That's not case, sir.
you will accept the blame.
No.
Are you blaming your predecessor or
That's
you want
what
to
he-
accept the blame?
What he is trying to say is that at that point of time, perhaps there was no format prescribed.
No,
Now
why
the
format is required?
prescribed.
Rule 2005 is there.
Now 2005 has come. It was in 2001.
They require spoon feeding.
What is that?
They don't know how to read the rules.
My lords, in view of your lordship's last order, the district magistrate is present in court.
Yes, which are the material information, material evidence that the petitioner has misappropriated sum of rupees 1 crore and all.
Yes.
What is the material?
The material evidence is the fake bills which had been prepared and submitted in the treasury, and the payments were
Fake
made.
bills.
Fake
It
bills.
is a part of charge memo.
Yes.
Show us from the charge memo.
Yes. Charge memo is, my lords, annexure 4 at page 30 of the brief, where it is,
Where is the list of documents?
the documents is not there. List of documents is not there.
Then how can you?
List of documents and list of witnesses are not there.
District magistrate, how long you are in the present post?
Sir, 1.5 years.
1.5 year.
Sir.
In how many cases you have decided, issued charge memo? In how many cases
Sir.
you have issued charge memo?
Sir, around 3-4 cases, sir.
3-4 cases.
In departmental proceedings, sir.
Have you issued article of charges, statement of imputation, list of documents and list of witnesses?
Yes, sir. There are a few formats, sir, issued
Have
by
you-
General Administration Department.
Then why it has not been followed here?
Recently, sir.
This was 2001.
One, sir.
This
It's
was
very old
this
case,
statute
sir.
is of 2001.
Correct, predecessor. You have to blame old people.
No, sir. No, sir.
Then
That's not case, sir.
you will accept the blame.
No.
Are you blaming your predecessor or
That's
you want to
what-
accept the blame?
What he is trying to say is that at that point of time, perhaps there was no format prescribed.
No,
Now
why
the
format is
is
required?
prescribed.
Rule 2005 is there.
Now 2005 has come. It was in 2001.
They require spoon feeding.
What is that?
They don't know how to read the rules.
That was 2005 rules. After 2005, things have improved. Earlier to 2005, my lord.
Sir, even after 2005, none of the disciplinary authority are following.
my lord, Now, therefore,
Then
the
we will set
government
aside
has
and remand the matter.
Therefore, my lords, the government now has prescribed a format that you have to fill those formats so that no mistake is.
There have been several judgments.
So just like school children, the state government is giving lessons how to frame charges.
My lords may remand the matter.
We will set aside and remand. Yes, who is for the petitioner? What is the age of the petitioner?
Yes,
What is the age of the petitioner?
55.
55.
minutes. Age of petitioner is 55 minutes. He
As
has
on
to
what
retire
date?
On 13 March 2027.
55 as on what date?
Date of birth. He has to be retired on the 13 March 2027.
20?
30 March 2027. He has to be retired.
27.
Yes,
27.
He has taken pursuant to the earlier order, district magistrate, Mr. So and so is present in the court. What was the post held by him?
This is routine clerk.
Huh?
Routine clerk. He was holding post of routine clerk.
Sorry, I can't understand.
Clerk.
He was
Clerk.
holding the
Clerk.
post of clerk.
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 Please take down. In the instant petition, petitioner has prayed for the following relief. So the petitioner, while working as a routine clerk, he is alleged to have misappropriated huge amount, and he was subjected to disciplinary proceedings in framing article of charges on 31/12/2001. Full stop. He had submitted his reply. Stated to have submitted his reply to the charge memo, and it was not satisfied by the disciplinary authority. In the result, the inquiry was held against the petitioner. Full stop. In the inquiry proceedings, the petitioner is stated to have submitted written submission on 15/1/2002. Full stop. The inquiring officer submitted a report to the district magistrate Patna on 8/4/2002, holding that the charge levelled against the petitioner were proved. Full stop. In the result, disciplinary authority issued a second show cause notice seeking petitioner's explanation on the inquiring officer's report on 22/6/2002. Sorry, don't put the date. The petitioner stated to have submitted his reply to the second show cause notice on 22/6/2002. Full stop. Based on the inquiry records, the disciplinary authority proceeded to impose the penalty of dismissal from service on 6/7/2002. Full stop. Feeling aggrieved and dissatisfied with the order of dismissal, he preferred appeal number 27 of 2004 before the commissioner, Patna division, Patna, and it was dismissed on 23/7/2011. Hence the present petition. Full stop. The learned counsel for the petitioner submitted that initiation of inquiry is not in accordance with the relevant rule as on the date of framing of article of charges on 31/12/2001, like providing a list of documents in support of the alleged charge, etc. In the result, further proceedings till dismissal of appeal are liable to be rejected and petition be allowed. Full stop. Per control and counsels for the respondent fairly submitted that list of documents have not been made available to the petitioner along with the charge memo in support of the alleged charge relating to misappropriation of a huge amount. Full stop. In the light of the aforesaid submission, on behalf of the state respondent dash district magistrate, to the extent that petitioner has not been provided opportunity of countering the alleged allegations with reference to documentary evidence on behalf of the prosecution dash department. On this point itself, the matter is required to be remanded to the disciplinary authority to commence fresh inquiry in respect of providing list of documents and other materials in terms of the relevant provision of law as on 31/12/2001 and proceed to complete the disciplinary proceedings within a period of 4 months from the date of receipt of this order. First, the petitioner shall cooperate in the aforesaid inquiry proceedings from the defective stage. First of next paragraph. The disciplinary authority / district magistrate Patna is hereby directed to take a decision as to whether the petitioner shall be placed under suspension or he shall be taken back to duty.
Rule 9(5).
For the reasons that impugned order of dismissal and appellate authority's order are set aside on technical ground. First up, Apex Court, the so and so, MD ECIL versus Karunakaran, read with Coal India, para 46 to 50. First up, recently, Apex Court in the case of so and so reiterated the aforesaid principle, which is reported in so and so. First up, next paragraph. The disciplinary authority is hereby directed to take a decision whether the petitioner shall be placed under suspension or he shall be reinstated within a period of 1 month from the date of receipt of this order.
My lords, rule 9.
Second one.
9(5) is there.
Second one, the disciplinary authority is hereby directed to complete the inquiry within a period of 4 months. Annexure so and so stands set aside. Dismissal order, appellate authority order. Yes, what do you want?
No, I was just indicating, my lords, what MDECIL says, my lords, is exactly incorporated also in the Bihar Government Servant Disciplinary Appeal Rules 2005, Rule 9.5.
But that is not applicable here because the old rules are applicable.
But the new rules
Have you
also
understood,
provide the
Mr.
same
District
thing.
Magistrate? Complete the inquiry within 4 months.
My lord, my submission is, my lord, the petitioner is under suspension since
Petitioner is
1997. He was not getting any subsistence allowance in spite of the order passed by the conducting officer.
No subsistence allowance from what date to what date?
My lord, his suspension was 15/7/1997. Since 15/7/1997. Annexure 2, he was suspended.
Up to dismissal.
Yes.
Up to dismissal.
Up to dismissal के बाद भी.
After dismissal, you are not entitled.
no,
That will be redetermined now. Yes, take on. District Magistrate is hereby directed to verify from his office as to whether the petitioner has been provided subsistence allowance during the period from suspension with effect from 15/7/1997 till dismissal from service so and so date or not. If the petitioner has not been extended subsistence allowance / enhanced subsistence allowance, in that event the same shall be extended to him within a period of 2 months from the date of receipt of this order.